Erring on the side of caution until you're the one paying the price for it. Better safe than sorry. That phrase sounds humane. In discussions about domestic violence, it feels almost morally untouchable. Of course we should err on the side of safety, right? Protect the vulnerable, prevent tragedy. But here is the uncomfortable truth. When a legal system deliberately errs on the side of caution, it always errs against someone, and those errors carry real consequences. Protective orders are preventative remedies. The law does not require a catastrophe before it intervenes, but the law does require proof. In Utah, a petitioner must show abuse by a preponderance of the evidence. That means more likely than not that it happened. Not possibly, not plausibly, more likely than not. That standard matters because every functioning legal system depends on a simple rule. When the evidence is evenly balanced, the party with the burden of proof loses. Imagine accusing someone of taking the last cookie from the jar. If the only evidence is your word against that person's, you lose, not because the other proved innocence, but because you failed to prove guilt. The same principle applies in court. If protective orders can be issued in a true evidentiary tie, then the burden of proof becomes decorative rather than meaningful. Here is where structural drift enters. Systems designed to minimize false negatives, failing to protect a true victim, naturally produce more false positives over time. The incentive structure explains why. A false negative can lead to tragedy and public scrutiny. A false positive is usually private. The restrained person may lose housing, access to firearms, reputation damage, but those consequences rarely make headlines. Institutional pressure therefore nudges decisions toward caution. Over time, the phrase, better safe than sorry, stops being advice and becomes a decision shortcut. But law cannot operate on shortcuts. Protection and proof must remain linked. When precaution replaces persuasion, the legitimacy of the system weakens. The answer is not dismantling protective orders. They serve an essential function. The answer is reinforcing evidentiary discipline. Courts should articulate specific findings tied to statutory elements. Corroboration should be considered when available. Sanctions should exist when allegations are knowingly fabricated. And appellate review should remain accessible when the burden of proof appears misapplied. Protection and fairness are not enemies. They depend on each other. A system that restrains liberty without disciplined proof does not become safer, it becomes less trusted. And when trust erodes, protection itself eventually weakens.